Good afternoon, everyone. Thank you for joining us for the Regulatory Hour in Review with Dale Atkinson. I'm Stacy Price, and I'm a member of the FSBPT Board of Directors. Today, Dale will provide a recap of some of the very important topics that we covered this year. So I encourage you to please prepare to engage in the discussion. Make sure you're ready to chat, respond to any surveys that might pop up, or unmute your lines when you're prompted to make statements or comments. We welcome that. Also, I ask that if you please plan to remain on for Shop Talk, which is a session after Dale's presentation, to kind of give you an opportunity to ask any burning questions that you might have, whether it be something about your jurisdiction or practice, or further discuss something that Dale talked about in this presentation, or simply to share your ideas about topics that you might like to see covered in the upcoming year. So please, please, please remain on for Shop Talk. And now over to you, Dale.
Excellent. Thank you, Stacy, and welcome everybody to the December edition of the Regulatory Hour. Sound is okay. Somebody give me a thumbs up that I can see. Excellent. That I can see a few of you. So appreciate you being here as we round out the year 2021 and roll into the year 2022. I do want to begin, as I always do, with a big sincere thank you, not only for being here, but for what you do for the regulatory community and for the public served. No matter what role you play, it's very important that the regulatory community be recognized. And of late, it seems like we, the regulatory community, is being recognized perhaps in negative lights, or at least being scrutinized and questioned. And so we welcome the scrutiny and questions, and we hope that the topics we've discussed throughout 2021 make you better prepared to address some of the issues that do come up. So a big thank you to each and every one of you who is on the line today. We are going to do some wrap up on the year end with some, I think, some important topics, and at least one case that I think has it's a pretty significant case, and we'll be discussing that. And as mentioned, feel free to chat and unmute if you have something to say. We're happy to welcome that. So to get us started, 1, 2, 3, and 4, you usually get some choices here of how you're feeling right now. And so hopefully some of you are some 4s, and but we may have a 2 or 3 or a 1 in there occasionally as well. And so we welcome that. This is to make sure you're listening, number 1, and number 2, making sure that you can navigate your chat features and others. I think we are all becoming veterans of Zoom presentations and Zoom participation. So we'll continue to do this because perhaps it's fun, but somebody type in a 2 there. There we go. We have 1, 2. Excellent. Okay. We need to have a little bit of if we're going to do this. As mentioned, I'm Dale Atkinson, and I certainly do not compare myself to the picture on the screen, but I usually put a famous lawyer up there just to, again, give us a jump start. As mentioned, I'm an attorney in private practice, and I represent a whole bunch of FSBPT-like organizations. And so I've dedicated my entire 34-year career to not-for-profit organizations like yours. And so hopefully some of that history and experience will help us today as we discuss some of these important topics. So there we go. Lincoln was born in Kentucky. Mark, thank you. So I can see the chats today, so I'm feeling all revved up and ready to go. We covered a lot of topics throughout the year, and I do look forward to continuing into 2022 on a regular basis as well. And so we will continue to solicit topics from each and every one of you, as well as I will throw in my comments as to what may be relevant as we roll into a new year. You can see in review here, 2021 has led to change. Change has been imposed upon us through COVID and other issues, not only from a regulatory perspective, but from a practitioner's perspective, which affects the regulatory community. So I will talk about a few things that maybe have led to some of this change, including probably most importantly, some of the political landscape that is percolating out there, that is giving added scrutiny to the regulatory community. So I've chosen to go with an acronym to kind of wrap up 2021 and get us rolling into 2022 using the acronym HELLO, and hello as to the incoming new year. And as we wrap up some of these topics, we welcome the new year. And I'm hoping that we all welcome the added scrutiny onto the regulatory community. And we do that with open arms, and we do that with confidence as to our roles we understand what the regulatory community is all about, and we certainly understand what we individually have in our roles as board members, administrators, executive directors, assistant AGs, inspectors, or anyone else, investigators. So homogeneous examinations, legislation, licensure, and onward is kind of where we're heading. Homogeneous, an interesting word that I've chosen because I think in 2021, we spent a lot of time talking about diversity, equity, inclusion, and everything else. But at the same time, we have to recognize there's a homogeneous state about us. And that is the common goal of regulation in the interest of public protection. And so I think it's an important concept to not lose sight of as we also talk about differentiating and the differences that we have as a United States, if you will, and not to go down too far some of these roads that are being discussed, but understanding how it is we share a common goal as regulators of public protection. And for those of you who have been on these regulatory hours on a regular basis, you've heard me talk about how really the role of a regulatory board is to carry out the intent of the legislation. That's the shortest, quickest, most politically correct response that you can have is we carry out the intent of the legislation. And theoretically, though, if we threw all the legislation into one bucket, we would have one common element of public protection. So it's regulation of the profession in the interest of the consumers. But homogenous as being defined there corresponding in structure because of a common origin. I think we all as a regulatory community have a common origin, and we don't want to lose sight of that. And the 10th Amendment of the United States Constitution empowers, if you will, the states to, through their police powers, regulate all the professions, physical therapy included. And so while we recognize how we share commonalities, we also are very deferential to the 10th Amendment and to each state's ability to regulate as they see fit. And it doesn't always come together so well, depending upon the profession. And in physical therapy, I think you all can be very proud about accredited education components, uniform licensure exam components, and you're well on the way to then realizing that you not only have that same common ground in mind, but you are able to recognize the state's rights. And so once we get past education, exam, and maybe experience the 3 E's, perhaps the rest smooths itself out, and it sets forth multiple issues. One is the recognition of the 10th Amendment and states' rights, but 2 is it also understands and recognizes the ability of you all through FSBPT to engage in and create mobility and portability programs like your compact. And so the second part of this homogeneous discussion really is the FSBPT. And this is not a promotional issue for FSBPT or any other like organizations. This is just a recognition of the fact that the uniqueness of your organization, it brings you together as regulators and allows you a forum by which you can discuss important issues and find the common ground and help direct your organization to do things that will be beneficial for all of the members, if you will, all the state boards that exist. And whether it's a compact for mobility, whether it's a uniform licensure exam program, or it's a registry of primary source data that's being held on behalf of the state boards, you name it, there are so many opportunities out there. And so as we begin rolling into 2022, it's a reminder of the important role that FSBPT and all other FSBPT-like organizations play insofar as assisting you all as the member boards. And I like to summarize it by saying FSBPT and other like organizations lessen burdens on state government by adding to the effectiveness and efficiencies through programs that they develop. And those programs are developed under the watchful eye of you as the members. And so this homogeneous commonality state, perhaps we can do a little bit of emphasis here while also understanding we do have DEI and other issues that are extremely important to society and everything else. So just a quick reminder to get us started here about the important role that each and every one of you play and how you can collectively make certain decision-making issues. The second letter is our E in examinations. And there's a very interesting recent case that came out of California. This is an unpublished opinion. So for citation purposes, for lawyers on the phones, be careful on the line, be careful, about issues. But let me tell you a little bit about this case and why I think it's so important. We had a student here, a medical student, seeking to become a physician, licensed physician, educated offshore and doing a practicum or the residency program, if you will, in California. Now, as an educated person in the Caribbean school, the individual passed parts 1 and 2 of the U.S. MLE, the medical licensing exam. And then on part 3, which you take while you're in your residency, this individual took the exam 4 times and was unsuccessful on all 4 occasions. So now we have an issue of 4 attempts. And so this brings to the forefront, the very first question is, should there or are there exam attempts related to access to a licensure exam program like yours and like all of my clients that do have? And so this is an issue that's been discussed and debated over the course of many years, and there's no real clear-cut right or wrong answer. And we certainly could get a lot of psychometricians in the same room and come up with many different recommendations. And so let's just think about that. How do exam limits come into play within your jurisdiction? So is it in your state law? That's question 1. And 2 is, does the exam owner, FSBPT, feel there should be exam limits as well for psychometric purposes in determining or demonstration of entry-level competence? And so I understand that FSBPT has a six attempt limit. And obviously, as we've talked about in the previous slide, your organization is deferential and has to be to state law. So if state law is silent, that's one thing. If state law says there's a 3 exam limit, that would take precedence. And so we would all come together and figure out how that answer would work itself out. So back to our facts now. So this individual took the exam 4 times and was unsuccessful. In California, where the residency was taking place, and presumably where this person wants to become licensed, in their statute, they have a 4 attempt limit on part 3 of the United States medical licensure exam. And so this individual who was taking a review course now to prepare for the 5th attempt. So here's our next question is can you even sit for the exam on that 5th attempt? Or might you be seeking licensure in a different jurisdiction? And so that's a question that the exam owners like FSBPT will grapple with and ensure that access is not denied, but at the same time recognizing the limits. So while taking a review course, preparing for that 5th attempt, apparently the individual who was providing the review course to this candidate suggested that he might have a disability related to his exam attempts. So the candidate sought a medical opinion and was diagnosed as having an anxiety issue and was prescribed medication. So the individual is now taking medication, took the exam on the 5th attempt and passed. Okay. The judicial opinion here that's cited does not identify whether there were accommodations given on that exam, but the individual at least was taking medication. Okay, fine. And did pass that exam. So now this candidate, Singh, introduced his 5th attempt passing score to the California Medical Board saying, I would like you to recognize this score for purposes of licensure. And the California board said, well, the statute says there is a 4 attempt limit, so we will not recognize your 5th attempt. So now we have another issue of, we have a 5th attempt which shows passing, and could this person, this individual, submit that score to a different jurisdiction? I suppose the answer is yes to that. If they got licensed in another jurisdiction and then wanted to endorse or reciprocate back to California, what would happen? How would the law be interpreted with this 5th attempt? So there's several legal issues that could have arisen out of this. However, when the board said, no, we won't recognize the 5th attempt, the individual filed a lawsuit against the board and its executive director, arguing under the Americans with Disabilities Act that this 5th attempt should be recognized as a reasonable accommodation required under the federal law. And there's also citations to the California specific disabilities laws as well. So there's a federal and state law argument that's being made. And the lower court in this particular case granted the board's motions to dismiss, and it did so without prejudice. meaning that this individual could not cure the defects in the complaint and therefore had no other remedy to reinstitute litigation on these same particular issues. The case was then appealed by the candidate to the Court of Appeals in California. It was decided, by the way, on October 22nd of 2021, so it's just a couple of months old. And the appellate court in California reversed the lower court. And I'm going to give you the ending first, and we're going to talk about how they arrived at that. And the appellate court said that a reasonable accommodation could be to count the fifth attempt toward licensure eligibility determination. So there's other factors, of course, education, good moral character, and other factors, file an application, pay a fee. But for purposes of the exam, the court recognized that perhaps this exam attempt should count as an accommodation. Now, because the case was decided on a motion to dismiss, there was no trial on the merits. So really, this is a remand back down. So from a technical standpoint, potentially there still will be a trial on this. But let's talk a little bit about the reasoning of the Court of Appeals, which is, I think, extremely important. Entities who are under scrutiny and to which the Americans with Disabilities Act applies have an obligation to provide accommodations to otherwise qualified candidates who are disabled. Okay, so it's pretty straightforward. But these entities, be they examined entities or otherwise, do not have an obligation to fundamentally alter their program. So the question on appeal in this case is recognizing a fifth attempt fundamentally altering a program? And some might automatically say, of course it is, because the statute said 4 attempts. And the court didn't necessarily agree with that. And it said statutes, like any other statutes, are subject to judicial scrutiny under the ADA, and whether they unlawfully, if you will, discriminate against disabled individuals. And what the court then did and exercised is it looked at the legislative history of the statute when it was enacted that said 4 attempts is the limit, okay? And based upon testimony and other written documentation submitted to the court, there was no real legislative history that distinguished between that 4th attempt and that 5th attempt. And so the court, kind of jumping to the conclusion here, said, without any substantiation to show that a 4 attempt individual is more likely to be competent and a 5th attempt individual is not more likely to be competent, without evidence that shows that, perhaps that this is not a fundamentally altering of the program. So the court made it very clear that it believes that that 5th attempt should count because it's not fundamentally altering the program, because there's nothing in the record that substantiates that there's a differentiation between a 4th attempt and a 5th attempt. And you could make the same argument, 3 attempts to 4 or 6 attempts to 7, whatever it is, and has remanded this back down. And short of some resolution otherwise, this case either could go to trial or something else will happen. Perhaps the board will choose to recognize this 5th attempt as one component toward the eligibility for licensure. And so we ask ourselves now, as we speak to exam limits, and I'm positive that FSBPT and my other clients as well debate these issues and try to determine what is best for purposes of ensuring the validity of their exam program, and how we might differentiate between a number of attempts where we recognize that the entity owns the exam, recognizes them as demonstrating entry-level competence and is willing to legally stand behind that, versus that next attempt, we are not willing to stand behind that because of all the psychometric factors that might be debated. And so I'm not suggesting 6 is right or wrong or 4 is right or wrong. I'm just saying this does create some significant legal debate in addition to the practical debates that I know went on with FSBPT and that are going on with multiple clients that I work with about these exam limits. And my last kind of editorial comment to this is, one, it's an interesting opinion. It's worth reading for those of you who are following exam attempt issues and those of you who might jump to the conclusion, and I don't say this critically, I just say this, we would jump to this conclusion that the statute says for, well, we can't change that statute, so we have no flexibility here. And perhaps you do under at least this appellate court decision. As I mentioned, October 22nd, it was decided, and there's probably more to come on this case unless there's a quick resolution to recognition of that fifth attempt. So I was going to make one last editorial comment, and now I can't remember what I was going to say. So we will keep an eye on this particular case, and I know that the debate of exam limits will continue on, and it's incumbent upon exam owners to understand the differentiation between whatever limit they choose, if any, and that next particular attempt that may or may not distinguish between demonstrating competence versus not. So lots of issues coming out of this. I'm not throwing into question anything that's already on the table, but it is a good read for purposes of determining exam attempts. So questions or comments about that? If so, type them in the chat or go ahead and unmute and shout it out. And if not, I'm going to proceed on. So a couple of chats here, an example of why data and research is extremely important. Absolutely agree. If you're going to differentiate between one attempt versus another, perhaps you need to know why. And then another one here, unfortunately, the AG served the clients, so will up until it was challenged, served well. So I'm not sure, Jason, if you want to clarify that, but if I'm understanding the comment, but it's an important case and it's something that we will want to keep our eye on. And I know FSBPT will take an interest in the analysis of this as well. So my next L here, or my next letter is L for legislation. And I want to tell you a little bit about Illinois Senate Bill 1632 and the process by which this went through to pass without a single dissenting vote. And I want to give you a little bit of history about it, because I think it's important for us to understand that decision makers, policymakers, elected officials, politicians, whatever we want to call them, may not be in the know about technical issues that are important to public protection and the licensure process. And so in Illinois, in February of 2021, legislation was introduced by an Illinois senator. It was backed, by the way, by the state chapter of the professional association. This happens to be social work, by the way. And so the state chapter of the social work profession was actually the impetus behind the introduction of this bill. So excuse me for a second. And so in February of 2021, it was introduced. It went through the appropriate channels, and I've written articles on this, and there's all sorts of issues we might want to draw by politics and political parties and committee structures and everything else. I'm going to blow past all that, at least just to tell you it went through the customary process of being referred to committee, discussed, voted upon with recommendations, back and forth, all the things that they customarily do. But eventually in April, so just a few months later, after it was introduced, it went through its third reading before the Senate, and it passed 56-0. Now, this bill, by the way, I guess I didn't tell you about it. This bill eliminates the examination as a requirement to become a licensed social worker. So what the bill is essentially doing is to become a licensed baccalaureate social worker. You do not need to demonstrate entry-level competence through an exam. And perhaps I might editorially add that they're relying upon the education component, okay? So here I believe is the inability or the lack of understanding by the elected officials to differentiate between an entry-level competence determiner, that being a licensure exam, and an educational component, and why they're both in statutes and the different roles that each plays. So a little bit about that in a minute. So in April, it passed 56-0 in the Senate. It went to the House then. It went through its committee process through that as well. And in May, so we're talking about just a month later, the House passed Senate Bill 1632, 117-0. So here's a bill now that receives 0 dissenting votes. Within a matter of a couple of months, it was sent to the governor's office for signature. Now, imagine a governor not signing into law something that passed through without any dissent. Well, perhaps we could, but it was signed into law. It does become effective in January of 2022, January 1st of 2022. So within a 161-day period, this legislation was introduced, discussed, voted upon, and passed. So now in Illinois, to become a licensed social worker, you do not need to demonstrate every entry-level competence through a licensure exam. So now we can all react to that and let that set in for a minute. Well, what does that mean? Is that important? Is it not important? And I don't want anyone on the line today to somehow infer that because of my representation of groups like FSBPT and ASWB, which is the FSBPT of social work, and they own and administer their exam program, just like you all do, that somehow that I am pushing this issue related to a bias toward a client, which is not true. I think the issue here is an understanding of the differentiation between an educational component and an exam component. An educational component of a lifelong learning preparation through multiple years, significant expenditure of funds, and the process by which academia and education go through to nurture, if you will, maybe that's not the best word, but to educate their student body and provide them with an X number of year period by which you can be assured that these individuals are matriculating through the system appropriately and ultimately then graduate, okay? Versus a licensure exam, which is a snapshot in time intended to ensure that individuals seeking licensure can demonstrate entry-level competence built upon a practice or job analysis and all the psychometric factors that go into validating an exam program. And so we can ask ourselves, well, are each of these components important? Yes. Do they substitute for one another? No. But I am not sure if those elected officials really could articulate the difference between an education component and an exam component. And quite frankly, I'm not sure all the regulators in our regulatory community, no matter what profession, could articulate the difference between an education and exam component. And sometimes, we need to ask ourselves that. So at what point in time can we be educators to those that are ultimately making these important types of decisions? And what role can organizations like FSBPT, or what role can regulatory boards play in ensuring that elected officials, politicians, understand the issues at stake prior to voting upon them? Now, I am going to suggest, I'll tell you all this in advance, I'm suggesting to all of my clients whom I assist in drafting their model acts and model legislation, is that we put into model legislation the fact that any substantive amendment to the Practice Act must be presented to the board prior to a vote, in the legislative branches of government. And I don't think that that's an onerous requirement. And obviously the elected officials don't have to follow the advice, but they should seek it, and they should understand what it is they're voting upon, whether it's a change in scope of practice issues, or it's something like Illinois here, elimination of a fundamental factor that demonstrates competence as a prerequisite to licensure. Now, can the legislature do that? I suppose they can. We could debate whether they can or they cannot. And so again, are we now delegating authority? Let me talk Illinois specific. Is Illinois now delegating authority to establish competence to the academic community? Is that the worst thing in the world? Probably not, but there are flaws to that, and there are certainly, I think, debating sides that we could take on that. And so I see a few comments that are coming in here about it's sometimes difficult to educate them. I'm assuming the politicians, when they don't care to talk to the boards on the issue. I absolutely agree. Absolutely agree. And so I think that if there is a mandate to bring substantive amendments to the Practice Act to the boards, at least they'll have something of record. Whether they read it, whether they follow it, that's up to the policymakers. And there's only so much that so-called we can do related to educating these policymakers. But in Illinois now, starting in just a few weeks, there will be no exam component related to entry-level competence for purposes of eligibility to become licensed. And so we'll keep our eye on that, and we will certainly continue to provide education to not only the regulatory community, but to the policymakers to the extent that we can, which brings me to my final point on this. I do a fair amount of board member training for my clients, and sometimes it's done in one room with multiple jurisdictions at multiple tables, and sometimes I go to one jurisdiction and talk to either one board or multiple boards intra-state. And I do this every year in Nevada. And Nevada, the day before I do the board training, they also set up a training session for elected officials, where I have an opportunity to so-called train. Maybe I would use a different word if there were elected officials on this line today, but where I speak to these politicians, these elected officials, about the regulatory community, why regulation exists, and the important roles that boards can play. And so are there opportunities here for all of us to continue to try to help educate, if you will, political or elected officials? Let's hope there are. We always get into the debate of lobbying versus becoming an information source. And obviously, I'm not suggesting that your boards, your state boards at each of your jurisdictional levels lobby. You're probably prohibited from doing that in most states. Nevada, by the way, ironically, perhaps is not prohibited from lobbying. And many of the boards in the state of Nevada actually hire lobbyists. So the point is how do we get the word out? So I throw that back to you all as a community of regulators and suggest to you that maybe we brainstorm about how best to have these types of issues that surface, and perhaps gaining some confidence in each other regarding the legislators and the policymakers making these decisions. So the next, any other comments about that? We've got Nevada boards have lobbyists as a comment. What do the endorsement reciprocity applicants do for social work? That's a really good question. And that will, I think, eventually surface. You will have Illinois social workers who wish to relocate, or, by the way, they wish to practice virtually and not physically be anywhere else, but they need to get a license in multiple jurisdictions that they will not qualify. The very nature of endorsement, by the way, is you are licensed under similar circumstances. And I believe that if you have not taken the competence exam, you probably will not be deemed to have been licensed under similar circumstances. So I would take a guess now, probably a pretty educated guess, that Illinois social workers will not be able to endorse their licenses into other jurisdictions. And I believe the political pressure on the rebound might cause the legislature to rethink this issue, but it is on the books for right now. And so, yeah, somebody else wrote Illinois may be the new gateway state. You know, it's a gateway probably into Illinois, but perhaps not elsewhere. And in the interest of time, I will just kind of wrap up this topic by saying this is why portability and mobility is so important, especially in a profession like social work that is perhaps more easily able to be practiced virtually than maybe other professions, physical therapy perhaps included, and that the definition of what is practice be clarified. And my approach to mobility and portability and virtual practice are to ask two simple questions. They may not be, the answers may not be simple, but the questions are simple. Is it within the scope of practice? Yes or no? And if yes, where does practice occur? And that tells me, do I need to have a license, and where do I need to have that license? And so while it's easy for me to articulate those questions, it may not be as easy to answer them. So, but this endorsement and movement is is a very great point, and I think it will come back to eventually back to Illinois. California has gone through that as well for purposes of not using exams. And California, with multiple clients, has been the last to come aboard to use the uniform exam in multiple professions. And I believe most of that was driven by the very question that was asked about endorsement, meaning California licensed people could go nowhere else. And go, like I've mentioned, can be physical movement or virtual movement. So kind of as the so-called wrap up, and I purposely for today's session tried to leave enough time to engage with you all as the attendees here, and that is as we move onward and we roll into 2022, and quite frankly, from one year to the next is no real difference. It's December to January. However, new laws do sometimes take effect, like in Illinois, as of the first of the year of a new year. And so I would ask for you all to chat or unmute and speak to any ideas that you have received over the course of this year, be it through the regulatory hours you've attended, be it through the other webinars FSBPT has put on, or be it through just the discussions intrastate you've had with other boards as to what you may implement as we transition into 2022. Does anything jump off the page at anyone that wants to unmute or to chat in and tell us what it is that you think could be perhaps brought to fruition in 2022 that will make you a more effective and efficient regulatory board? Don't be shy now. There's 29 people on the line, so somebody can unmute and talk about it. Any issues we've brought up? We'll just scroll through these chats as well. There's a few issues here about lobbyists and others. Anybody have anything to say? What have we learned here? Applications for licensure, renewals, continuing education, continued competence, licensure exams. What's within your control? And so I'll throw out a question then, and somebody can maybe help me answer this. And I don't mean to create controversy in how I phrase questions, so I don't mean to do that. But is the regulatory structure within your jurisdiction one that is conducive to making changes that help in the effectiveness and efficiencies of boards? And I do talk about this topic somewhat regularly, and that is depending upon if you are standalone boards, if you are composite boards, if you are departmentalized jurisdictions, whatever it might take. And does that play a role in some of these issues? And how do how do the FSBTs of the world and the regulatory community, how do we best communicate with the decision makers? So we've got some compact comments that are coming up. We've got a Nevada comment that just disappeared because a new comment came in, but about perhaps getting rid of lobbyists or the ability to have them boards lobby. So that's an interesting question, an interesting concept as well. And as compacts continue to evolve, is that going to assist in the effectiveness and efficiencies of the regulatory community while at the same time recognizing the 10th Amendment and the autonomy of the states? Another comment here about evaluating the impacts of the pandemic on regulations, telehealth, documentation. There's also HIPAA issues and others that come into play as we expand the electronic presence of practitioners. Silence is golden here. Silence hopefully is going to make some of you speak a little bit, maybe. Is anyone seeing an increase in requests under the disabilities law, federal or state, related to applications for licensure? We saw the ADA case related to exam attempts. Are you seeing additional issues within the applications themselves? As I brainstorm some of these ideas, I'll throw out a few concepts that I think are pretty important to be thinking about. One is reviewing your applications for licensure and renewal. And if you have not done that of late, do that. Get your lawyer involved and look at the questions that are being asked and decide two things. One is, do we need this information? And if the answer is yes, how do we best phrase the questions to determine, to gather the information that we think that we need? And I believe as we become more sensitive to issues related to all the issues that are on the table now related to, say, gender, ethnicity, race, age, marital status. We can think of a lot of factors that people might not be as willing to want to disclose. And I would suggest you ask yourselves, do we need to know this and why? And I'm not saying any of those topics I just brought up you don't need to know. I'm just posing the question as to how that might come into play related to that. And then secondly, with groups that are out there, let's call them libertarian groups or others who are somewhat challenging the involvement of government, they do seek information from regulatory boards, and I've seen this on multiple occasions, about data gathered by state boards. So for instance, you might, under your open records laws, you might get a request from an organization that says, we want all your applications for licensure for the past 5 years. And then with that, analysis will be done by outside groups, so-called outside of your control as regulators. And conclusions might be drawn from those. So for instance, if every single application that comes in, there's a license granted, some will argue, and I'm not saying there's merit to this argument, some will argue, well, why do we even have the regulatory board? Everybody qualifies. Now we know the flip side of that is those that seek licensure have met the requirements, and they know they've met the requirements, but that's one of the issues. The second big issue related to applications for licensure that I am seeing as a trend is the ability, or now inability, of regulatory boards to assess good moral character, specifically criminal background issues. And legislation that is providing what they call second chance legislation and others, which I fully support, but it does perhaps limit the ability of the board to look into the criminal history of the applicants for licensure and prohibit that board from even considering some of the criminal history that may exist. Some of it's driven by time frame issues and others. So if there's a conviction that's over 5 years old or something, to just use an example, perhaps you cannot consider that. And as I have argued, if you will, or discussed in the past, the elements to a criminal setting are, you're arrested, charged, convicted, pardoned, or expunged. You can be exonerated, of course, as well. But and at what point in time are those factors relevant to you as a regulatory board? And you need to know if you've ever been arrested. You need to know if you've ever been charged, if you've ever been convicted, if you've ever been pardoned or expunged. And the lawyers on the line, we could debate whether you can even ask those questions about expungements or pardons, especially in a setting maybe dealing with an individual who is a minor. So I'm kind of getting way off topic here, but I'm floating ideas out there to try to get somebody to unmute and say something. So I see a couple of comments here. We're seeing an uptick in interest in returning to work after 5-year gap in licensure. So re-entry to practice. What a great question there. Do I need to be actively practicing in order to renew a license? So if I take time off to have a family, raise children, whatever it might be, and I continue my CE and I continue to file my renewal application, but I do not practice, do you care? Do you even know, or do you want to know? Versus I go inactive, assuming you have some kind of an inactive status, and after 5 years, I now wish to reactivate my license. And you now might ask me, well, gee, are you competent on current issues related to the practice? And how do we assess that? And of course, in Illinois, you're not going to be taking an exam, I guess. I can chuckle about that issue, but so, anybody want to tell us about that? How does reactivation, if you will, or must I actively be in practice? I'm purposely avoiding the COVID questions a little bit. One, I'm a little tired of them, but two is, I believe in the end there will be, and I don't say this lightly, but there will be good about the modification because of COVID, as far as recognizing some electronic issues and some of the other things that are probably going to remain. Even something perhaps as simple as virtual board meetings. And there's good and bad to all this. I get it, but I think there'll be some things out here that will become more permanent, that perhaps make you more efficient. And remember, the reason that I focus on effectiveness and efficiency a lot is because that's the standard by which you will be judged as a regulatory board when you're under sunset review or or anything else. And so insofar as maintaining your status as a regulatory board itself. So still looking at some chats here.
Dale, I am
Yeah,
happy to.
Dale, Michelle had unmuted. Go ahead, Michelle.
Excellent. Michelle, go ahead.
Hey, Dale, I'll particularly since the reentry to practice was one that I put in, I'll frame out just a little bit more, because when Oregon would use the option tool when that was available, but otherwise, unlike some states, we don't have a very specific algorithm for, like 1 year lapsed, 3 years lapsed, 5 years lapsed. We just have general language about needing to prove competence if not licensed for 5 years or more. But part of what, in looking at creating some of that structure to move away from where we are now, which is where we assess it case by case, it's an interesting question in that for reciprocity, by endorsement, you just need to have an active license, but we don't require on that or track whether you've been practicing under that license. Whereas if the license then lapses, then there is that critical look to actual practice, not just being licensed. So there also seems to be, well, we're having some conversations about that potential disconnect between the various pathways that you can come into licensure, particularly when the individual wasn't previously licensed in Oregon, but rather in another state where it may have expired a couple of years ago. That's something that from the group, if anybody feels that they've really sort of nailed that from a rule and reg standpoint to make that manageable. But also we're very interested in the work of the Continuing Competence Committee and hopeful that 2022 brings some additional research behind what just sort of how to assess that effectively, depending on how long somebody's been out of practice. So I'll pause there, but would love to hear from others.
And if anybody, please unmute and chime in. And Michelle, I'll just ask you a question here just to kind of keep this going. And that is what's the definition of being out of practice?
Well, that's exactly the point. Often to renew your license, it's based on an active license, which may or may not have an active practice requirement. And whether that's clinical practice or working in the education realm or for an organization like the Federation, it's we don't have a clear requirement for that kind of practice. It's about active licensure, right? But then when you want to return to practice, when you've been unlicensed for a period of time, you have to prove competency either through taking continued education or some kind of an assessment. But looking at our practices, it seems that there are, 53 jurisdictions and maybe 64 variations on how that might work. To kind of poke fun at that a little bit, but I'd rather have it be science-based, right? That if we say if you've not been practicing at all or taking any kind of continuing education for X number of years, then you should be taking this kind of additional coursework or something like that. That's kind of what we would love to see. When we tell people they have the option of taking the MPTE again, a lot of people balk at that. But
and I've said this before, I think during the months of these regulatory hours, and I'll say it again too, is in my field at least, and I would probably suggest maybe in others as well, is if I knew I had to take the entry-level competence exam every 10 years or something, I'd be prepared to take it. And we all should be able to demonstrate entry-level competence at any point in time in our careers, understanding that we specialize and and there's difficulties in mandating that, but I kind of go back to Michelle, your active license, and I would ask anybody on the line do you have an active license, and then do you have then an inactive license, and do you call them active or do you just call it license and good standing and some of those issues? And as I renew, I may not have practiced all year, but I took my CE, and you may or may not care. And I think Stacy, you were unmuted. You wanted to say something?
Well, I was gonna say, I mean, she's absolutely right. And it's why the whole research perspective on this is extremely important, because we have no data to say at what point you start losing some of that entry level competence to continue. And then there are those that are of the mindset that the market will take care of it, right? So if, you know, you are renewed or you're issued a license and you've not practiced for so long that wherever you go to get a job is going to do the necessary training for you to do what you need to do to be competent in that setting. They may not be competent in every setting, but in that setting. And that's truly, I think, when it comes to legislation or developing regulations around it, that's the rub for, especially with government oversight for a lot of our jurisdictions now. When you're trying to put in those parameters or those years, if you don't already have them, or you're trying to change them or amend them, not having the research or the data to show the legislators, then they just don't want you to put it in there at all. And so it becomes an even bigger problem when you're trying to amend it. But I think that we're probably in the same boat that you are, in that it is different depending on which way you come in. And at the very least, within your own board, it should be pretty even across the board, you know, whether it's inactive for a certain period of time or whether you completely lapse for a certain period of time. I think everybody should be treated the same. And even additionally, with those people who are continuing to be licensed but have not practiced, I think, you know, there should probably be some, you know, additional competence there as well. And you know, CE right now is the only option most of us have to, you know, keep the renewal, and not necessarily a minimum number of years or minimum number of hours that you have to practice between renewing.
And keep in mind that any, through rulemaking, policy, or even statutes, anytime there are these factors introduced that you must be a full-time practitioner, you must have practiced X number of times per week or month or year or whatever it is, you as a board have to figure out a way to enforce that uniformly as well. And so the more detailed you get, don't forget that the more it opens you up potentially to not only the administrative burdens of it, but the legal consequences of inconsistently enforcing it. And so there's a lot at stake, and I hear that when I used to, or I bring that point up when I used to hear a lot about limited licenses, and it used to come up regularly with language. You know, I don't speak English, I speak Spanish, I want the exam in Spanish, or whatever, you know, the issues are, and I only plan to practice in a community whereby they speak the same language I speak. And if you are trying to recognize that, which I don't recommend, but if you were, you'd have to someone force that and say, well, now you can't practice in an English speaking community. And how in the world would you ever police that, if you will, or better word, enforce that and some of those difficulties? So the same thing is true with, you know, if you're going to require someone to be in full-time practice or 20 hours a week or whatever it is, you're going to have to figure that out. So I'm a little interested, if I can just bring up, if anybody wants to unmute, is there anybody on the line who has an exam attempt limit? Quickly back to that ADA case. And is it in statute? And do you know anything about the legislative history that led to the enactment of that statute?
Dale, before that, Jason had his hand up. I don't know if he had a comment on the last topic
Excellent.
before you.
Jason, go ahead.
I did, but Dale led me right into the next topic, and so I don't know which. I'll do the first one first, and that was just that, you know, California is probably a good fishbowl to look at with all the different professions, and the fact that within our own jurisdiction, every profession handles the idea of return to practice differently, right? And even very closely related professions have a almost opposite kind of viewpoint, that return to practice is very important, where another profession might think that it's not, and that as long as they're able to prove entry-level minimum competence, then we've met our mandate as a regulator. Exam attempts, California doesn't have exam attempts per se. We actually have an exemption. We have a prohibition against tracking exam attempts or even withholding the examination based on failure. So we have kind of which is funny because the case law we just discussed is specific to the Medical Board of California and how they've actually gone into their Practice Act and through, I guess I would probably say, the powers of special interest groups enacted this 4-time ban for Part 3. But for the rest of us, even like the 6-time lifetime ban for FSPPT, we have this huge hurdle to kind of have to get over, and not just changing our Practice Act, changing the general provisions of legislation as they pertain to healthcare practitioners and getting something like a lifetime ban of any sequence enacted.
Yeah, those are great points. The inconsistencies intrastate can be as difficult as the inconsistencies interstate and the recognition of states' rights. And I wish, as the simplistic mind that I have, that all the boards in the state were called the same thing, the State Board of Physical Therapy Examiners or something, and then every board followed that same thing. Oh, no, we can't do that. And so they all have a little bit of different issue. And I know when I do board training, I make people introduce themselves and give me the formal name of their board, because a lot of them say, oh yeah, we're the social work board, oh, we're the physical therapy board. Well, what's the real name of it? It's something as simple as that, let alone we get into the deep issues of exam attempts or active practice and renewals. So good points. And I don't know if California would subscribe as much to the national, if you will, not a good word, probably other state pressures of, hey, the uniformity is helpful to us and to you and to everyone who's moving around and ultimately the consumers. So, and
that's the thing that I would add to it, is that you really do have to demonstrate that uniformity is helpful, right? To get anything changed legislatively speaking in California, is we are going to have to demonstrate why any standard would be necessary to impose upon the licensing population. So in the case of like a lifetime ban, it's not just proving it on FSPPT's behalf, but it would also be proving it for FSMDs and nurses and all, and all these others to try and get over that kind of hurdle.
Excellent. We're approaching the hour mark, but anybody else have any comments about, let's say, exam attempts limits that are set in statute? And I think while I know you're all waiting to unmute and say something, I will throw in an exam attempt limit is probably a statutory issue. I don't think you can regulate. I don't think you could promulgate a rule that places a limit on that. It'd probably be argued it's outside the scope of your authority as a board to do that, but we debate that. But anybody else have a statute that limits their exam attempts that wants to chime in and relate this to that the same case?
It is interesting that you just said that, Dale, because we don't have it now, but the Physical Therapy Board in Georgia did have within their rules the number of attempts for passing exam. And we had a 5-time limit. It was not in the statute, yet they were able to enforce it for many years. And when FSPPT went to the 6-time limit with their exams, then that's when it was removed, and it was just, done according to whatever the owner of the exam does. So, but it was just in the rules. It was not in the statute.
And I might suggest if your law is silent, okay, and I'm not sure in Georgia if it is, but if it's silent as to exam attempts, a good legal argument could be made that an outside entity like FSPPT, which, by the way, I don't consider an outside entity because you are FSPPT, you make up the membership. But there may be an argument made that you can't live by that rule because it's not set forth in law anywhere. And so you can have a big old debate about that, good or bad, and whatever happens is going to happen. But it is an interesting topic. So, but I would suggest if some of you have it in rules but not in statute, and the statute might say limitations as set forth by the board or is promulgated by the board through rule. If it gives you that authority, okay, no problem. So, but be cautious about that. And really, the basis behind my comments we're right at the top of the hour here. Basically my comments are to educate us all about the issues so you can ask the questions and get them answered. You know, it's not, these aren't all about giving you answers here on these regulatory hours, but it's more of an educational setting issue. So Stacy, I'll turn it back to you, but I will say this to everybody on the line. One, thanks for being on the line. Thank you for your attention over the course of the year, and FSBPT, Rich and your staff, and to Bill, you know, happy holidays to everybody on the line, but thank you for having me be a part of your regulatory hour this year. And I look forward to continuing on in 2022. Stacy, back to you.
Thank you very much, Dale. You're always making us put our thinking caps on, which is really good for our various jurisdictions. We appreciate that.